I've been listening closely to the discussion in Part 1A of this bill. I know that there's been a number of specific questions put to the Minister that would be very helpful if he actually gave the House the courtesy of taking a call and responding to. And I'd like to hear specifically from him on a number of issues, particularly around that issue of ministerial responsibility and how the Minister will make decisions. And I want to talk a bit more about that issue because it goes to the heart of this bill, which is the Minister making decisions about the structural separation of telecom without regard to the people who are going to be most affected by that, and these are the consumers, the people of New Zealand, the users of telecommunications services, the users of broadband, who are unlikely, the vast majority of them in both urban and rural New Zealand, to actually get access to fibre, which is supposedly being promised by this Minister, by his government, won't get access until at least the end of this decade, and the more that's being revealed about this issue, the more it's being revealed as being a big con. So I would like the Minister to address specifically how he sees this part of the bill in Part 1A at 23B, 23C and 23H. As how he sees that decision-making process taking place, and what issues will he take regard of, what advice will he take regard of, and what consulting will he do with the regulatory body, with the industry and with the public who are going to be affected, which is why this amendment, which actually inserts new paragraphs, and ensures that he must take consideration of the promotion of competition for the long-term benefit of end users, must take account of that, is so important. And just in relation to that, I want to mention the purpose clause of the Act, which is where a significant change has been made in this legislation around taking away the balance for the competition of long-term of end users and putting into a much stronger weighting the regard, the interests of the investors. In fact, putting the investors above the interests of end users and the long-term interests of end users and the importance of competition in that area. And this is why it's such a significant issue that needs to be addressed, and why that clause at 23B brackets 3, 23C and 23H is so important. And I would like to hear from the Minister today how he is going to make that decision, those decisions around the structural separation, and who he's going to listen to and consult with in doing that. And I'd also like to address again in a bit more detail the issue, the proposed amendment at 23ZE, which is going to allow the parties to take legal proceedings against Telecom for breaches of the current operational separation. Now, this is another important issue that we need to hear from the Minister on, because the Minister needs to explain to the public, to this House and to the public of New Zealand, whether or not existing breaches that are being heard in civil action against Telecom will continue to be heard, how that will happen, and what happens in the interim before structural separation takes place if there are breaches that do occur, and how can the public be assured that they are going to be heard, that Telecom will be held to account. Because there have been a number of breaches of undertakings. There's been a number of other anti-competitive behaviours which my colleague Trevor Mallard has mentioned a couple of times in the House today, 19. I think it's at least 19. And there's been a most significant one in recent times where Telecom was fined $12 million, which is the largest fine through such an action that this country has seen. our argument is that these, Mr Chair,
to you, Karen,
that these issues are significant enough in this bill and in this legislation where the structural separation of telecom will create entities that are still as yet unknown how the separation of those entities will occur, where the competition will be able to occur in the community at the retail level. And there's a lot of concern, and there was an enormous amount of concern expressed during the select committee phase about how the accounting separation will occur and where it will occur, which is why the public needs to be reassured that the anti-competitive tendencies that exist within telecom won't be replicated in the new entities, particularly in the new Chorus 2 body, which, and just for the purpose of the public and the people across the House who won't really have a clue what this means, is that at the moment telecom is divided through operational separation into three different parts: a retail, a wholesale and an infrastructure level, which has clear delineations between each of those parts, and the undertakings are important between each of those parts. Under the new arrangement there will be two parts. And so a large part of the middle part, the wholesale part, will end up in Chorus, and that will give Chorus an advantage in the industry. It will, and as yet it is unknown where that separation will be, and it will be the minister who makes the final decision and makes the final call around that without having to take due regard, which is why we need checks and balances within the legislation, so it's not all on the minister's head in terms of making the right or the wrong decision. And it doesn't matter who that particular minister is, that responsibility should not just be put on the minister without having to take due regard, and without having to particularly take due regard of the benefits of long-term benefits of end users. So, which is why these amendments are so important, and why the minister really does need, who has sat in this House all afternoon and taken one call on this bill. And I would like to think that he's been listening and taking note and paying attention and actually taking seriously the serious issues that are being raised by the members on this side of the House and with the Greens around these issues, because they are really important and they go to the heart of how we can trust a structural separation taking place in our biggest company, in one of our biggest companies in this country, and how we can trust the processes that have been put in place by this government around that. My colleague Grant Robertson talked about transparency. Well, this government likes to pretend that it's transparent. How about demonstrating that it's transparent by getting up and telling this House how you're going to make those, how the minister is going to make those decisions, and reassuring the public of New Zealand that they are going to be done responsibly, and that there's not going to be a secret process, a behind closed doors discussions that don't involve the rest of the industry, and don't allow the rest of the industry to have input, and don't allow particularly the people of New Zealand to have input. And the reason that I keep talking about the people of New Zealand, Mr Chair, is because at the moment there's another gaping hole that's appeared in this government's broadband scheme, and that's in a place called Zone 3. And Zone 3 is a bit like Harry Potter's Hogarths, which is, where do you go? Is it the platform 9 3/4? I thought it was platform 9 1/2, but apparently it's platform 9 3/4. It's a place that sort of doesn't really exist, and there are potentially up to 470 schools. The minister insists that it's much less than that, but he hasn't provided a list of them, and I've got a list here, Mr Chair, of those 470 schools, and they are in communities like all over the country, big communities. Southland, Invercargill is a serious part of that of the Zone 3.
Chairman?
Mike Woodhouse.
I move that the question be now put.
Trevor Mallard, the Honourable.